I'm sure you all are familiar with how many different ways the right wing, the anti-immigrant forces have been trying to limit the life of immigrants. And I hate to say that they've been very successful. They've ratcheted up from their initial program that would have been limited training and including of police to do the work of immigration and ICE, to now the secure communities, which is there without any real legal authority, but is totally pervasive and affecting us at our very local level by engaging local police in doing the work of identifying, many times racially profiling, and detaining individuals.
So this is an honor. I'm going to lead the conversation with some of the nation's leading experts on the intersection of state and local immigration laws and federal policy, which is a hot topic, as we all know.
Well, who we call these restrictive issue entrepreneurs, and we can talk about that more later, they played a two-level game very effectively. They were able to ground legislation to a halt at the national level and remarkably turn around and say, look, the national system is broken. We need to empower states to do things because there is no solution at the national level. The pro-immigrant integration movement is borrowing some of the lessons from the past, from the restrictionist efforts, but also from a lot of the hard work that they did battling this legislation, in which they are no longer just thinking about the federal legislation as the be-all and end-all. They have to be paying attention to the state level, and that's what we're seeing today.
Right.
So when you think about a case like United States versus Arizona, which we'll get to in more detail, and the broader types of omnibus enforcement legislation that you saw with SB 1070 or the copycat legislation in Alabama, Georgia, and other jurisdictions, what you see is a very sophisticated attempt at crafting legislation that gets at this play in the legal joint, so to speak, right? And so this is legislation crafted to work in the interstices where the court has previously not had any clear pronouncement as to whether states can or cannot be in that area, which is why for many years, SB 10, or at least 3 years, SB 1070 was viable, or 4 years, until the court finally struck down most of it. But there are certainly still places where states and localities still have room to operate. And I think that's what we'll be talking about a little bit more today.
What happens in the federal sphere and what happens in the state sphere aren't separate. They're interrelated. And part of the justification, as he also laid out, for some of the state actions on these laws governing immigrants is the lack of federal action. But I think we've also seen that federal action in itself, times when the federal government has acted, that also has spurred on state action, sometimes positive, sometimes negative.
I want to kind of challenge us to stop thinking about Dreamers as only shaping the public narrative, because a lot of state measures are also coming together because Dreamers are the ones doing the political strategy and defining what the goal and what success looks like is at the state level.
We call a specific set of actors restrictive issue entrepreneurs. If you're talking about a rogues gallery, there's so many, right? But we don't look at people like Jan Brewer, for example, or Russell Pierce. Who we talk about as issue entrepreneurs were people who were critical to playing this two-level game and to proliferate legislation. And kind of the premier actor in all of this is Chris Kobach. When people look at copycat legislation, they say, wow, these things start looking so similar to each other. Well, it helps to have a common author. You had this issue entrepreneur who was testing out legal theories, identifying places that would be most receptive to this, and even trying to get new places to pay attention to this work. So you see legislators in places like Arizona and Alabama grateful for someone like Kobach to provide the legal expertise.
And I should mention here that, this is a critique perhaps of integrationist or pro-immigrant movements, is that I would say that you can start in the 1980s and 1990s and even in the 2000s, a significant I think, faith, perhaps too much faith, that federal courts and the federal legislature were going to be the solution to restrictionist or nativist focus, to nativist forces. It very well might be a place to place energy, but I think what the last decade has shown is that there are other ways of being more effective, or perhaps as effective or more effective in achieving those ends, and that might be at the state and local level, especially in light of what might be a predicted longer stalemate on immigration reform at the federal level than most of us would want.
Well, as responsible issue entrepreneurs, we're fighting on all fronts.
Yeah.
I think the litigation is ongoing. I think beyond that, we're fighting at the state level. We're part of a project of I think now about a dozen states that puts together advocates and fiscal groups that tries to push forward, and national groups to provide some national technical assistance to push forward some of these more integrationist policies. We do have toolkits on our website on both tuition equity and on driver's licenses. And folks can find them online, www.nilc.org. I believe we have model legislation there. And all sorts of resources, and then we're trying to fight the good fight at the federal level and make sure that none of these gains that have been made at the state level are undermined by something done federally.
And then I think in terms of the federal reform, how do you bring down the number of deportations? You can look at, I think it would be great if the administration decided tomorrow or today, we're going to end the Secure Communities program, a program that has just been done terrible. I don't think there's a nice way to put it. It has just been detrimental to the community. It has had terrible impacts at the local and state levels. And I think the stats for places like California, where the Trust Act has been passed, I think the LA Police Department is not honoring 80% of ICE hold requests. And it's statewide in California, I think the number is about 51% of ICE hold requests are not being honored because of the Trust Act.
In the work that I did in California in 2003 and 2004, it's no accident that these laws are called the Trust Act, because law enforcement wants to maintain trust in local communities. And they do not want to be playing immigration cops. It makes their work harder because they have much more serious crimes that they're trying to solve, and they depend on the trust of local residents to solve what they feel to be much more important crimes like murders and very serious crimes.
Well, we share Lorella's view that the president can do a lot more than what he has been doing to decrease the pain that's being felt in the community from these deportations. And one simple thing, or I guess one obvious thing, would be expansion of the DACA program. It's not clear what are the limits of his ability to expand the DACA program, but we think they're just certainly greater than the DACA program as defined or as implemented today.
We're right, they're wrong. We have to keep up the good fight, and this won't be the last chapter. All right, thank you everybody so much, and a big round of applause for the